Good morning and welcome to the Office of Tax Appeals. I want to go ahead and inform everyone that we are currently live streaming. Just going to give everybody a moment here to be joining our hearing and get ready. Um, so my name is Judge Long, and this hearing is for the appeal of Chow and Chan. This hearing is being auto-transcribed. To ensure we have an accurate record, we ask each person to speak one at a time and avoid speaking over each other. When needed, I or another panel member will interject to ensure proper transcription. After the hearing, OTA will produce the official hearing transcript, which will be available on our website. As a reminder, OTA is not a court, but is an independent appeals body, which is staffed by subject matter experts and is independent of the state's tax agency, Franchise Tax Board. I want to ask if there's any questions about anything I just said before we go on the record.
No, we're
All
good.
right, I'm seeing shaking heads. So with that, I'm going to see if my panel members are ready to proceed with the record. All right. So with that, we are going on the record. This is the appeal of Chow and Chan, OTA case number 240415998. The date is October 9th, 2025, and the time is 9:44 a.m. This hearing is being held electronically with the agreement of the parties. I am Judge Long, and I'm the lead administrative law judge for purposes of conducting this hearing. However, my co-panelists, Judge Lee and Judge Johnson, and I are all co-equal participants in deliberating and determining the outcome of this appeal. I'm going to ask the parties to identify themselves and who they represent, starting with Franchise Tax Board.
Yes, good morning. My name is Leo Cristobal, and I represent Respondent Franchise Tax Board.
Good morning. My name is Maria Brosterhouse, and I also represent Franchise Tax
And now, Mr. Langer.
Fred Langer. I represent Leo Chow and his wife, Julia Chan.
All right, thank you. Now, both parties received the minutes and orders following our pre-hearing conference, and you are notified that Judge Johnson is replacing Judge Leung on this panel. Judge Lee is also going to replace Judge Vasig on this panel due to availability. I'm going to ask if either party has any objection for good cause to these replacements.
No,
All
no
right,
objections.
thank you. Hearing none, we're going to move forward. So as stated in those minutes and orders, the issue to be decided in this appeal is whether appellants have established reasonable cause to abate the late payment penalty. Now, FTB submitted exhibits 1 through 6, and I'm sorry, appellants submitted exhibits 1 through 6. FTB did not object to the admissibility of these exhibits, and therefore exhibits 1 through 6 are admitted into evidence. Mr. Langer, did you have any additional exhibits today?
No,
All right, thank you. And FTB submitted exhibits A through D. Appellants did not object to the admissibility of these exhibits, therefore exhibits A through D are now admitted into evidence. Now, Mr. Langer, we're going to go ahead and move to you, and you may begin your presentation. I believe you requested 10 minutes, and you can start whenever you're ready.
okay. Um, Basically, the reason we appealed this penalty is I've been working with this firm, Skidmore, Rings and Merrill, Leo's firm, for since back in the late '80s, and the company does a really good job of providing them their accountants, us, on a quarterly basis with the information we need to prepare quarterly estimated payments. Then they provide information usually the first week of April so that we can prepare the extensions and send in money that's owed.
Mr. Langer, I'm going to ask you a quick question. I
Sure.
want to know if you have, it sounds like you have personal knowledge of this case. So do you work with, you said the firm? And is it the firm that employs the taxpayers, the appellants in this case, or with the firm that prepared their individual return?
When I say I work with the firm, I'm an independent accountant. I do a lot of the partners' tax returns individually.
And did you prepare the appellant's returns in this case?
No, I did not.
Okay, so do you
They were
have,
prepared by Paul Johnson out in California. He handled the California partners. I do the Illinois partners, and then another gentleman handles the New York partners. Those are the three main offices. Paul Johnson was forced to retire. He had severe medical issues, and then once that happened, I flew out to California to meet with all the partners to take them on because I had been so familiar with the company. These are very complicated returns.
I
Uh,
understand. The reason that I ask is because when you are giving your presentation, you have the option of testifying as a witness, which would mean I would have to swear you in. And that means that any factual statements that you make about your personal knowledge can be considered as evidence and testimony for appellants. However, if you would prefer not to be under oath or don't have personal knowledge of those facts, then anything that you say in your presentation would be considered argument, which is also considered, but it's not the basis for findings of fact. Does that make sense?
yeah, you're talking legal to me, but that's
All right.
yeah,
Well,
it's fine.
I only ask if you'd like me to put you under oath so that to the extent you have personal knowledge, it could be considered as testimony and evidence for appellant's case. Would you like me to put you under oath?
I don't know. Is there any need for it? That's um,
Well, it's
that's up to
absolutely
you.
your choice.
Yeah,
So
but
I'm going to leave that up to you. You can go ahead and continue your presentation. If you change your mind at any time, I can
okay,
place you
all
under oath.
right.
So please continue.
Yes, and the only reason I brought that up is that I do several of the partners, and I'm doing the California partners and the Illinois partners, and the firm, their controller, accounting department provides us with the information we need to calculate the money that's owed. Right now, we're finalizing all the partner returns that are due October 15th, and if all the information provided was in line with the projection or the estimate or draft that was given to us in April, everyone should be in good shape. Shouldn't be any money due. It should be right where we think it is. And this year it is. In the year that we're dealing with, when I went out there and met with the partners and got copies of prior year returns, I saw that all of them got hit with large penalties for the 2020 year. And I said, "Boy, how did Paul mess this up?" And I looked at the K1s; they didn't provide enough information to send in the correct amount of money. There was a huge add back on all of their K1s. In Leo's case, it was 1,700,000. And, that was, if they would have given us that draft to, calculate an extension amount, I would have probably sent the same amount in that Paul had Leo send in. And, he owed, 90,000 plus come October, and that normally doesn't happen. It's, uh, everybody does their job, and I don't know what happened. I think part of it was COVID. I think there was a lot of moving parts during that year with legislation. There was a IRS issued a Technical Corrections Act on the treatment of leasehold improvements, allowed the company to write off. They remodeled a couple offices. Maybe I know California and New York did not allow that. Maybe there was a late decision on that. I don't know. I think that was what the components of that add back were. Nobody knew about it. We weren't provided that information. Paul wasn't provided that information. And that's why, I told the partners, I said, you know what? I said, this really wasn't your fault. Let me try and appeal the penalties. It doesn't make sense. I would have sent in the same money. Like I said, the firm usually does a very good job. They send us, each year gets better and better. We get detailed spreadsheets that you wouldn't believe with all the add backs, adjustments, PTE, DISC. They're very good. They're one of the add backs to California. In fact, they were doing it wrong. For the California residents, California doesn't allow they want the interest charged disc dividends added back for apportionment purposes that affect the non-residents. Well, they were adding it back to the California resident K1s, and the firm called Paul and said, "Hey, make sure you're not, you don't have to do that. You don't have to add that back because otherwise you're adding back the dividends. They're residents, they're taxed on it anyway." So everybody gets better each year with providing information. And my whole idea of writing or responding, asking for reasonable cause was, look, guys, they made a company didn't provide them the information. That's what the extension payment was based on. It was a surprise when everybody got a bill. Right now, I've got all their returns. If I, give them a bill of 90 grand, they're going to say, okay, what did you do wrong? What did the company do wrong? Nobody's expecting that, and it rarely happens. I think that was just a year that information wasn't as good because of COVID, whatever, all the legislation that was being passed, and it just got missed. So, but I don't think in any way that was the taxpayers' fault. And that's my story.
All right, thank you, Mr. Langer. I'm going to ask my co-panelists if they have any questions for you about your presentation. Judge Lee, do you have any questions for Mr. Langer?
No questions at this time. Thank you.
All right, Judge Johnson, do you have any questions?
Yes, Judge Johnson. No questions. Thank you.
All right, I also have no questions. With that, we're going to move to the Franchise Tax Board. FTB, you have 10 minutes for your presentation. It may begin when you're ready.
Great, thank you so much. Good morning. As I mentioned, my name is Leo Cristobal, and I represent Respondent, Franchise Tax Board, or FTB. The issue in this appeal is whether appellants have met their burden of proof to establish that their failure to pay their tax timely for the 2020 tax year was due to reasonable cause and not willful neglect. Despite filing their 2020 tax return by the extension deadline, appellants did not pay their full tax on time. When taxpayers failed to pay their tax timely, FTP is required by law to impose a late payment penalty. When FTP imposes this penalty, the law presumes the penalty was imposed correctly. And to overcome this presumption, appellants bear the burden of proof to establish that their failure to pay timely was due to reasonable cause and not due to willful neglect. In this case, appellants have asserted that they relied on their accountant to calculate their tax liability based on a draft K-1 from the underlying entity at issue. They argued that they ultimately received unexpected California income from the entity and that the additional income was reported on a final K-1 that they only received later in the year. However, FTB reiterates that a lack of necessary or accurate information by itself is insufficient to meet a taxpayer's burden of establishing reasonable cause. And as has been determined in case law with the OTA, the determination of whether reasonable cause exists for a late payment requires an analysis of the taxpayer's actions leading up to the late payment, the timing of those actions, and whether those actions reflect ordinary business care and prudence. Additionally, it is also well established that an acceptable reason for failing to comply with tax obligations will only excuse such failure for as long as that reason remains valid. Here, as it relates to timing, appellants have argued that they would have paid sooner. They would have paid the tax sooner if they had known they owed it. Um, Notably, in their appeal letter, appellants did not specify the exact date that they received the final K-1 reflecting the additional California income. Additionally, after FTB submitted an opening brief highlighting this missing information, appellant's reply brief also failed to acknowledge the date the final K-1 was received. Furthermore, on the bottom left corner of the final K-1 provided in appellant's appeal letter, it is marked 7/13/2021. Based on that marking, it appears appellants received the final K-1 on or around July 13, 2021. However, appellants have not denied or refuted that this was the date the K-1 became finalized, reflecting the additional income. Consequently, the evidentiary record indicates that the relevant K-1 became final on July 13, 2021. Therefore, on or around this date, appellants should have known that they owed additional California tax. However, appellants have not explained why they did not make payment shortly thereafter, with their payment only being received by FTB approximately 80 days later on October 1st, 2021. Moreover, appellants have not justified why their payment was not made concurrent with their return, which was filed on September 7, 2021. The only action for appellants to do after computing their tax liability and filing their return, was remitting payment to FDB. Instead, their payment was only made more than 3 weeks later on October 1st, 2021. In conclusion, appellant's arguments and evidence are insufficient to demonstrate the kind of business care and prudence that ordinarily intelligent and prudent taxpayers would have exhibited in a similar situation. Despite the opportunity to do so throughout the course of this appeal, appellants have not met their burden of proof to establish that their failure to pay timely was due to reasonable cause. Accordingly, appellants are not entitled to penalty abatement, and FDB's action denying appellant's refund claim should be sustained. Thank you, and I'm happy to answer any questions you may have at this time.
All right, thank you, Mr. Cristobal. I'm going to ask my co-panelists if we have any questions for FTB. Judge Johnson, do you have any questions for FTB?
Judge Johnson, I have no questions this time. Thank you.
Judge Lee, do you have any questions?
This is Judge Lee. No questions. Thank you.
All right, with that, we are going to go back to Mr. Langer. Mr. Langer, you have the option to go ahead and take 5 minutes to respond to FTB's presentation. Would you like to go ahead and make a closing statement or a rebuttal?
Sure, sure. In terms of the K1s typically come out historically the end of July, anywhere between the end of July through the middle of September, because there's an entire package. There's three or four entities involved with the firm. Two of them are on a fiscal year, two or three of them are on a fiscal year, the other one's on a calendar year. So as much as a lot of times the taxpayer may get that particular K1 LLP, but they won't get the disc K1 till September 15th since it's on a calendar year. This year, for example, they came out the first week in August. Well, they came out the day before I headed on a trip to Europe for 2 weeks, so we don't have the always have the opportunity to get the returns right out, and no one really looks at, you know, anything. Once everything comes in, you can't get the return out till the whole thing comes in. And in terms of payment, I mean, I'm sure Leo was probably a little bit shocked that he owed 90 grand and maybe had to scramble to get that cash and didn't have it laying in the checking account to send it in right away. I just don't see how you know someone could he sent in a payment in April based on the best information available at that time. I don't know, you give that information to 100 accountants, they're going to send in the same number based on that income. Some might be a little more or less conservative, you might have a little difference, but in terms of it not being unreasonable for him to send in, I don't see him questioning the firm. Hey, by the way, are there any is there 1.7 million in add backs that I should worry about? I just don't, that's just not practical. They take the information that the firm provides them as a good estimate of what the year was. I really feel, and I had mentioned before that one of his partners, we had his penalty was abated for reasonable cause, identical situation to this, Larry Chin. And that went through the small case. He was below, I don't know, 2,500 or 5 grand. So we didn't have to go through we went to the short route, whatever that is. So I disagree with the franchise tax board. It's like, if they would have done that this year, we would have had owed 90 grand right now. We're filing Leo's return probably tomorrow. They're just that complicated. You can't, this isn't like picking up a $250 return. It's a 400-page return. I can't get those out the minute that K1's issued. So, I mean, I don't know how it can't be reasonable. I'm really surprised at their decision.
All right, thank you, Mr. Langer. Does that conclude your presentation?
Yes.
All right, with that, I'm going to turn to my co-panelists to ask if you have any questions for either party. Judge Lee, do you have any questions for either party?
No questions. Thank you.
All right, Judge Johnson, do you have any questions for either party?
This is Judge Johnston. I do for Mr. Langer.
Yes.
Mentioned in the briefing that uh, the majority of the additions, California additions that came through on the final K1 were related to perhaps the CARES Act, which passed on March
I
27th.
think a lot of it was, yes. And it wasn't, there was a provision in the CARES Act that needed to be corrected. It had to do with the write-off. They had remodeled offices, the Chicago office and New York office. It was a last-minute change. Uh, they've passed it through. I didn't have the impact of, my partners didn't know in Illinois because Illinois allowed the full deduction for the leasehold improvement write-off. California and New York did not. The firm did not provide that information to the partners, and therefore they got hit with huge balances due because of the add back. And
Uh,
I don't see how you can hold the taxpayer responsible for that.
yeah. And in your brief, you also mentioned that the partnership was aware of that kind of law change, but inadvertently omitted it from California resident partners K1s. Was that more of a they knew but they made a mistake,
I don't
or
know.
was
I
it?
don't know if they knew it or if it was just the information they got out in 2020 and 21 during COVID was not as detailed as it typically is because of everybody's working remotely. I have no idea, what caused that issue. I didn't have that problem with my partners, so it never came up. So I'm not quite sure what caused it, but if you see the information they provide today, it is, I mean, they've got so much more detail than that particular year.
Okay. Yeah. Thank you very much. No more questions.
All right, I also do not have any questions for either party, and with that, we are going to go ahead and close the record in this case. This case is submitted on October 9th, 2025, and the record is now closed. I want to thank everyone for participating today and for your patience as we got started this morning. The judges will meet to deliberate and decide this appeal. We will issue a written opinion within 100 days, and today's hearing in the appeal of Chow and Chan is now concluded. OT